Hello, I am a VCAT member. How may I help you?
I am an owner in an owner's corporation, and I have some questions in regard the process of VCAT hearings.
No problem. We are very open and transparent at VCAT. I can give you my opinion on matters.
Firstly, if I only have a small claim worth less than $10,000, will I be able to be represented by a solicitor?
People can represent themselves at VCAT and they do a very good job. Generally, we don't allow solicitors.
But what if the person is not a good talker in a court situation?
If an individual requests to be represented, I always say to them, "You sound okay to me. You can represent yourself." I have seen some people represent themselves and do better than the opposing solicitor.
So solicitors are allowed at VCAT?
If a person makes allegations against a manager or owner's corporation at VCAT, we don't believe this is fair, and therefore we allow solicitors under these circumstances. If an owner's corporation has a complaint against an individual owner, we also the owner's corporation to be represented.
So basically owner corporations and managers can always be represented regardless. Also, some people are emotional involved in the case. This must hinder them arguing their own case.
I can assure you that VCAT always gets the final decision right regardless.
But you can only get the final decision right based on what the applicant and respondent actually say in the documents they present.
We always get it right. Of course, each member's opinion on cases and interpretation of the act varies.
Solicitor's word is also apparently considered to vary in currency to the non-legal person.
Yes, this means their information is more reliable, and their legal knowledge can be used to help the member decide points of law and outcomes of cases.
As credibility is a key, this must provide solicitors an advantage.
Solicitors are under oath to assist the court. Naturally, we respect solicitors and listen to what they say.
I have the impression VCAT do not think it's just when applicants make serious claims.
Applicants can make whatever claims they wish.
Okay, according to Section 144 of the Owners Corporation Act. As I am in an owner's corporation, I have the right to access documents of the owner's corporation, including financials.
What? You want the owner's corporation financials? Why?
Our financial records do not appear to add up.
Listen, I realize you do not have legal knowledge, but the owner's corporation is required to act as the Owners Corporation Act says, and if you question financials, you're effectively accusing them of fraud. At VCAT, we don't like individuals who make serious allegations.
Well, how can I gain access to the financial records?
You can obtain them through Consumer Affairs.
Yes, but I have already spent months with Consumer Affairs trying to do this. What a waste of time. The Owners Corporation refused to hand them over and Consumer Affairs referred me to VCAT. I trust I will not be given the runaround by VCAT as well. Surely the law has to mean something.
Once you start accusing people of fraud, they have a legal right to protection, and you will have to make a claim to get the documents, with proof of your claim.
Why do I have to prove my claim just to access documents that the Owners Corporation Act says I am entitled to?
We only use the Owners Corporation Act as a guide. You will have to seek your own legal advice on that. I advise you not to list a serious claim against the owner's corporation or a manager without proof.
So what you're saying is I have no right to obtain the documents, and therefore it's impossible for me to accuse the owner's corporation or manager of fraud as I can't prove anything.
How can the manager be accused of fraud when Section 27 Clause 3 legally allows the manager to take the corporation's funds and place the funds in his own personal bank account?
That does make it hard. Maybe this is why the manager laughs when VCAT is raised.
Plus, we don't like owners fishing for evidence.
Regarding financial statements, the Owners Corporation claimed to have lost some of these.
If they have lost statements, they no longer exist, so therefore they can't supply them.
Even though the Owners Corporation Act says the Owners Corporation must keep all records for 5 years.
The Owners Corporation Act is only a guide. If they don't exist, they don't exist, and they are not required to supply them.
So this effectively means the Owners Corporation is accountable for nothing, as they can just claim all documents are lost. I have dropped into a couple of hearings, so I know what to expect. In one hearing, the owner was making serious claims against the manager and Owners Corporation.
We don't encourage false claims.
The manager never turned up to the hearing, and because of this the member blamed the owner, as the owner did not remind the manager of the upcoming date of the hearing.
I don't comment on cases.
It is bordering on childish. In another case, the member spent 15 minutes talking the individual out of commencing the case against the owner's corporation, saying there would be implications, etc. This seems typical.
No comment.
I went to a hearing. The owner's corporation was represented by solicitors.
We allow owner corporations to be represented by solicitors. This is fair.
The owner's corporation could not prove their claim about unpaid fees, and it was referred to a negotiation hearing. Technically, the owner's could not prove their claim. Yet the member placed the owner's corporation's solicitor's fees in reserve, possibly to be paid by the individual later.
Win or lose, we don't like the owners of the owner's corporation paying legal fees when they are not directly involved in the case. If we do not approve of the claims made by an individual against an owner's corporation or manager, we will make them pay certain costs before the final hearing, so their time-wasting case is not worth pursuing. VCAT members have the right to do this. If an individual makes serious claims, they will have to pay to get justice at VCAT.
Individual owners have claimed they have been threatened and harassed by a number of owners. Despite this age where cowardly bullying by numbers is condemned by the public, it appears the member barely raised an eyelid.
That is a personal issue of the owner that he or she can easily sort out. We do not waste time on such trivial matters.
When I walked into VCAT, a video stated that if the member could not resolve the issue, then it would be decided by which side was in the majority.
That's right. We protect owners of owners' corporations against the minority.
That means the owner's corporation is always going to beat an individual owner. Is that fair or just?
There are rules of the Owners Corporation Act that apply to owners. We strictly apply these to owners, and the rules are the reason why owners always lose serious cases. Rules are rules. Owners always win small cases in return. Our aim is to resolve issues without cost to the majority. That is the priority.
Oh, so justice is not the priority. If you found an owner's corporation or manager guilty of fraud at VCAT, what penalty can you apply?
We have wide sweeping powers at VCAT.
And the maximum penalty is
$250.
Did you say $250 maximum penalty? What's the point? Is there a reason why owners' corporation hearing results are rarely detailed and listed for public viewing?
Owners' corporations have to follow the act, therefore they cannot commit fraud, so of course no owners' corporation or a manager has ever been found guilty of fraud at VCAT. Owners' corporations that are run by professional managers do not get ripped off. I will have to ask you to leave the room now.